Well, good afternoon, distinguished guests and colleagues, and thank you for joining the Law Library of Congress and the United States Supreme Court for the 2024 Supreme Court Fellows Program Lecture. My name is Aslihan Bulut, and I have the honor and privilege of serving as the Law Librarian of Congress. It is my pleasure to send greetings from the beautiful Coolidge Auditorium of the Library of Congress's Jefferson Building to both our in-person audience and all of you watching us online. Let me just say a couple of words about the Law Library of Congress. The Law Library serves as a custodian of legal and legislative collection of nearly 3 million items from all countries and legal systems around the world. Our skilled staff of attorneys and law librarians provide research assistance and reference services on United States federal and state legal issues. Our foreign law specialists are a diverse group of foreign-trained attorneys who provide foreign, comparative, and international law research and analysis to all three branches of government. Our team is responsible for developing the collection for more than 300 legal systems, including foreign and international jurisdictions, as well as the U.S. states and territories in all formats. Each month, the Law Library hosts free webinars on topics covering U.S., foreign, and international and comparative law, and we invite you to sign up for these webinars on our website, law.gov. We are so honored today to have the U.S. Supreme Court Associate Justice, Honorable Elena Kagan, at the Library of Congress. I want to mention that our manuscripts division contains papers of many Supreme Court justices, and the Law Library of Congress is a proud repository of the Supreme Court records and briefs collection. So after the event today, we hope that you will return to explore these wonderful collections. And at this time, I would like to ask that you please silence your phones, and I'd also please ask to refrain from taking any audio or video recordings or photos of the event. And with that, I'd like to introduce the counselor to the Chief Justice of the Supreme Court of the United States, Judge Robert M. Dow, Jr. Thank you.
Thank you so much, Aslihan, and sincere thanks to Dr. Hayden and everyone here at the Library of Congress for hosting the 2024 Supreme Court Fellows Program Lecture. I am honored to welcome you here today in my dual roles as Counselor to the Chief Justice and Executive Director of the Supreme Court Fellows Program. The Fellows Program celebrates its 51st year, and I am pleased to tell our audience a little bit more about it today. The Fellows Program offers mid-career professionals, recent law school graduates, and doctoral degree holders from the law and political science fields an opportunity to broaden their understanding of the judicial system through exposure to federal court administration. The Supreme Court Fellows Commission selects 4 talented individuals to work for one of 4 federal judicial agencies for a year-long appointment here in Washington, D.C. Those agencies are the Supreme Court of the United States, the Administrative Office of the U.S. Courts, the Federal Judicial Center, and the U.S. Sentencing Commission. All fellows gain practical experience in judicial administration, policy development, and education. They also benefit from time to study and write, and from a vantage point in which they can develop an academic research agenda as well. It's so wonderful to see so many of our fellows alumni. I saw some of you on the walk over. In the audience today, and also the finalists for our 2024-25 Fellows class. Every class of fellows is special, but this year's class, I want to tell you, is composed of exceptional individuals who are talented lawyers and good-hearted humans. And I see them walking all the time into our building. I sometimes even encounter them over at the administrative office. And I will say my phrase for them is all for one and one for all. They are so supportive of each other. And they've also adopted what we call in the counselor's office our mantra, which is other duties is assigned. Because there are many times in which working for any of those agencies, but I think particularly over at the Supreme Court, you never know what each day is going to bring. And this class of fellows has been wonderful in pitching in wherever they're needed. So let me just tell you a little bit about each of them. Adam Kugler is the fellow assigned to the Federal Judicial Center. the Education and Research Agency for the Federal Courts. Adam joined the Fellows Program from the U.S. District Court for the District of Connecticut, where he clerked for the Honorable Sorella Nagala. I know Adam's future boss is sitting right in front of me here. I saw him. There he is. They're both there. All right, they're right. Believe me, the bright lights are here. It's hard to pick anybody out, but Adam's future boss is Judge Bill Nardini. He's sitting right in front of me in the Second Circuit. So Adam, you've got a good home to go to when you leave us. Adam earned a BA in political science and a JD, both with honors from the University of Connecticut, where he was the managing editor of the Connecticut Law Review. The fellow assigned to the Supreme Court and the counselor's office is Tori Nickel, and she joined the fellows program from private practice in Missoula, Montana. She previously clerked for Judge Sid Thomas of the Ninth Circuit and Judge Don Malloy of the U.S. District Court for the District of Montana, which, believe it or not, is one district. Tori earned her BA summa cum laude in political science from Carroll College and a JD with high honors from the University of Montana School of Law, where she was co-editor-in-chief of the Montana Law Review. And Tori has truly mastered other duties as assigned. Our next fellow is Viviana Vasiu. She's the fellow assigned to the U.S. Sentencing Commission, which is the agency responsible for the establishment of sentencing policies and practices for the U.S. courts. Viviana joined the fellows program from the U.S. District Court for the Southern District of New York, where she clerked for Judge Gregory Woods. She previously clerked for Judge Anthony Porcelli of the U.S. District Court for the Middle District of Florida. Viviana was a participant in the Attorney General's Honors Program at the U.S. Department of Justice, serving as a trial lawyer in the money laundering and asset recovery section of the criminal division. So if you have a problem in that area, she's your person. She earned a BA summa cum laude and a JD magna cum laude from Stetson University, where she served as editor-in-chief of the Stetson Law Review. Our fourth fellow is Jose Vasquez, who's assigned to the Administrative Office of the U.S. Courts, the central support agency for the judicial branch. Jose joined the Fellows Program from the U.S. Court of Appeals for the 11th Circuit, where he clerked for Judge Adalberto Jordan. He previously clerked for Judge Jacqueline Becerra of the U.S. District Court for the Southern District of Florida. Jose earned his BA in government from Georgetown and his JD from the University of Miami Law School. Both degrees earned magna cum laude. So we have four really smart fellows. Adam, Tori, Viviana, Jose, you all have been a joy, and we're happy to say that your experience is only half over. So we will look forward to seeing what you accomplish in the remainder of your term. I now have the joy also of introducing our two guests for today for your lecture. Chief Judge Jeffrey Sutton has served on the U.S. Court of Appeals for the Sixth Circuit since 2003 and has been its chief judge since 2021. He's a current member of the Executive Committee of the Judicial Conference of the United States, and most pertinent to today's events, he is the chair of the Supreme Court Fellows Commission. Previously, Chief Judge Sutton has chaired the Committee on the Rules of Practice and Procedure and the Advisory Committee on Appellate Rules. He's an academic, too, having taught at The Ohio State University College of Law since 1993 and also at Harvard Law School. He's best known in the academic world for his work on federalism and his casebook on state constitutional law. Chief Judge Sutton clerked for Judge Thomas Meskel of the Second Circuit and Justice Antonin Scalia. Justice Elena Kagan has served on the Supreme Court of the United States since 2010. Prior to her appointment to the court, she was the Solicitor General of the United States, the federal government's top appellate lawyer, sometimes referred to as the 10th Justice. Prior to that, Justice Kagan was the very popular and successful Dean Kagan of the Harvard Law School. She had previously been a law professor both at Harvard and at the University of Chicago. She served in the Clinton administration as associate counsel and as deputy assistant to the president for domestic policy. Justice Kagan clerked for Judge Abner Mikva on the D.C. Circuit and for Justice Thurgood Marshall. Please join me in welcoming two of my favorite people on the planet for what I'm sure will be a fun and far-ranging conversation.
You can see me, I can't see you, but
Thank you, Judge Dow. So another slow day at the office.
yeah.
I want everyone to know.
Everybody's laughing, so they must know what I did this morning.
No, I think they see the irony that this is the big part of the day.
I was kind of thinking the opposite. It would be impossible to make any news today because everybody would be focused on the morning, which I think, that's good.
I'm going to see what I can do. But I will point out that the Fellows Commission set this date long ago in the fall, and
You know that because if they hadn't, I would have said no.
well, and it says so much about you that you agreed.
That I didn't cancel immediately.
That is exactly what I'm saying. And so anyway, and it's an honor to be with you anyway, but today in particular. So thank you, really appreciate it. So I'm thrilled to be doing this. So your father was a lawyer, your mother was a teacher. You did both.
And I was a lawyer and a teacher.
So you did. So this is easy to understand. So they had a big impact on your career choices. But were there any other teachers or coaches that had an influence on you?
I think constantly. I think every place I've been, I've had great mentors, and I think this is true of most people, right? You don't. People help you along the way. And people help you a lot along the way. And I've been really lucky every place I've been. I've had people who have looked out for me. So I guess I'm a little bit reluctant to name names because I'm afraid I'll miss people. Because, truly, I've had a lot of jobs. Used to be that before I got this job, sometimes people would introduce me in the way Bob introduced me, and it would be so clear that I would change my jobs every 4 years. That I would say, well, now you know the secret about me, I can't keep a job. But every place, there's somebody that I could look to for advice and support and counsel, and I don't think you can do stuff unless that's true.
All right. Well, I'm not going to let you get away with that
Do you have a
entirely.
particular person?
I do, but you're going to have to save those questions till we're done. But how about your writing? I think everybody here would love to know who might have been some of the influences on your writing.
Well, the first influence on my writing was my mother. So my mother was an elementary school teacher, and this was something that she thought about, was how to teach young people, and she cared a lot about good writing. And so that was my first influence, was that she I think, taught me to write. I think the second person, I will name names for this one, because I think there are two people who are a little bit head and shoulders above everybody else in terms of writing. The second person was my senior thesis advisor. I went to Princeton. You had to do a big paper your senior year, and I was a history major, and I had really the extraordinary opportunity of working with a very young professor at the time, who is not so young anymore, but Sean Wilentz at Princeton.
Yes.
And I did my junior paper with him and my senior thesis, and he literally went over every page of both multiple times and taught me better ways of writing. And I learned an extraordinary amount from him, about being a good historian, I guess, for that time. But the stuff that really, really has made a difference in my life is I came out of that experience a much better writer than I went into it.
Mm-hmm. So, and now shifting a little bit to court opinions, when you think of your writing, you're obviously trying to explain why you're doing what you're doing, but do you have an audience in mind when you're writing?
I do, and I don't know if this really makes sense, because some of the opinions I write, probably the only people who read them are, the lawyers in the case, and maybe some set of lawyers who specialize in the subject matter.
Try being a Court of Appeals judge. It's worse.
Yeah, but I try to not think about that. I try to not think about, the only people who are going to read this opinion are specialized lawyers. I really try to write so that interested Americans can figure out what I'm saying and why I'm saying it. And you try not to dumb it down too much, so there's a balance you have to strike, because you don't want to dumb it down. You want to be, in terms of the substance, sophisticated and to treat difficult things as though they're difficult things. Mm-hmm. But at the same time, I guess what I would like is that it should be the case that even you know, if they don't understand every in and out, that an interested person with, you know, some amount, you know, I guess I think of myself as like writing for, you know, serious newspaper readers or something like that. You know, that they should be able to pick it up and sort of get the gist and figure out why it is that the Supreme Court decided what it decided today.
Do you ever have your mom's voice in the back of your mind? Like, what would mom think of this?
I mean, I think that would be a little
She
bit
was the
scary,
non-lawyer.
honestly.
She's the non-lawyer.
It would be a little bit scary. You could never really meet her standards. So she was tough. So I have a more generous voice, you know.
Well, I'll jump ahead to a point I wanted to talk about a little bit later, was Justice Scalia. He had something similar with his father. My understanding is his father would mark up his D.C. Circuit opinions,
Oh my gosh.
send them back. So
If my
couldn't avoid it. He
mother
couldn't
had
avoid
been
it.
alive by the time I started judging, she would have done the same thing. Yeah.
Well, while we're on the topic of Justice Scalia,
You know, it's funny when you said that, because one of the things that I've sometimes said about Justice Scalia is, you know, just sometimes Justice Scalia and I'll give you a little bit of a shock. Sometimes we were on different sides of an issue.
I'm trying to think.
And I used to have a little Nino Scalia voice right over here.
So effective at that. He did the same thing to me.
Okay, except you were probably on different sides less often. But I used to think, like, what would he say about this argument? And that's an extremely helpful thing to have. It's like, okay, if I know what how Justice Scalia is going to try to pick apart this argument, then you figure out how to make it stronger so that it will be less vulnerable to the great Justice Scalia dismantling. Now, whether you could really ever do that, you know, he always had things to say, notwithstanding my efforts. But sometimes I did. I thought of him a lot. Like, you know, what's he going to say about this? What's he going to admit is good? And what's he going to think is like really?
Oh, he was the
worst?
best. He never gave out compliments, but when he did, you knew they were real. And I'm sure he did
Absolutely.
occasionally to you.
Yeah.
Well, I know firsthand he had tremendous respect for you. He was thrilled when you went on the court.
You should talk about your relationship with Justice Scalia. Why are we talking about Justice Scalia? Is because
Okay, so I
Judge
clerked for him.
Sutton clerked for Justice
Yeah, so,
Scalia.
right, so that, exactly, thank you. But as I know firsthand from that experience and staying in touch with him, he was thrilled when you went on the court. He had tremendous respect for you and a lot of affection for you. And
You
so-
say that as though it's like surprising.
Well, you're
a nice
the one that
person, Jeff.
you're the one that introduced the point that you didn't always agree. So the thing that I think some people in the audience might assume, lawyers or not, is that people that disagree about the meaning of the Constitution might have a hard time having a close friendship. And maybe you could explain how that worked, because I think
Yeah.
it did work. You did disagree.
It totally did work. I mean, you know, I had an enormous amount of respect for him and the kind of judge he was, first of all. But I also just liked him enormously, and we were good friends. I mean, I found him an extremely generous, funny, warm human being, which is not necessarily something that you get when you read his opinions. You know, that kind of personal warmth. But he was, you know, a wonderful colleague. He had a great sense of humor, and he was a great friend. I mean, he was a great friend to a lot of people, and he cared about his friendships a lot.
Yeah. Well, you clerked for Justice.
He used to say, by the way, about this business about disagreeing. I mean, one of the things that I heard him say many, many times was he said, you know, you can't take it personally. If you take it personally, you're in the wrong job. Meaning you can't take what, you know, if I'm writing the majority and he's writing the dissent or vice versa, especially if I was writing the majority, he was writing the dissent, and he comes at you really hard. But, you know, he would say, look, plenty of people came at him really hard, and you just can't take it personally. That's not the nature of the business. And so, you know, that was one of the things that I actually learned from him, is it wasn't personal. It was, you know, he believed very strongly in some ideas, and I believed very strongly in other ideas. And so there was nothing personal about it when we went head to head, and you shouldn't take it that way.
Well, I heard him say it many times. I tried so hard tried so hard to internalize it, it's never worked. I can't think of a time I got a dissent from one of my majorities, or I'm writing the majority, someone else is dissenting, where the first time I read it, I said, well, this is not about me. This is just at a level like this, and
No, it's
how
not
fun,
about. It's not about the ideas.
how
it's not
fun,
about
yeah,
the
let's
law,
just
it's not
discuss the
about-
ideas. No,
Yeah.
I find it a lot easier to discuss your ideas versus Justice Scalia ideas,
Uh-huh.
'cause then I'm not in the middle of it. I find it very hard. I think it takes a lot. Maybe that says something about me, but
He once, there was one opinion. I don't. Some people would know what this is, where he really went after not only the opinion writer, which was not me, but the opinion joiners. And he said, like, if I had ever joined an opinion like that, I would put a paper bag over my head, or something like that. And you read that, and I take your point. It did seem a little bit personal. But
I learned early on that I was not going to try to be like Justice Scalia, not only because I didn't remotely.
well, I
have
have to
his
say that I
intellect or his
do. I
writing.
mean, I don't. Nobody quite has the wit of Justice Scalia, but I have a sharp pen too, where I can, and so it would be the last thing I would do was to say, "Oh, that's really terrible," because I've been known to be pretty. I've been known to be a little bit acerbic myself.
Well, I would put it slightly differently, and I'll not put it in those terms, but I would say that Justice Scalia had courage. So take Morrison versus Olson. It took courage to be a lone dissenter. Chief Justice
the
Rehnquist
year I
writing the
clerked
majority.
was the year he wrote that dissent.
Then you would know.
Extraordinary, because it was this was the constitutionality of the independent counsel case, and everybody else thought, well, it was just it was very different time, different view of the law, maybe different experiences that the country had had, and everybody thought, well, of course the independent counsel statute is constitutional, and 8-1, and he wrote this lone dissent, and like everybody else thought it was crazy, and it turns out to be one of the great dissenting opinions of all time, and to have a lot of, not just in terms of the way it's written, but it had a lot of prescience about some of the difficulties of having an independent counsel and what you should be concerned about. It's not necessarily to say that he was right, but it is to say that he wrote an extremely effective, good, and in many respects prescient dissent, and it just shows you sort of like how time can give you a different perspective, because at the time, really, like everybody was walking around the court going, what is he doing? Why is he doing it?
So maybe that's, in his writing, sometimes he was too courageous. That might be the way I would put it. He was too courageous with his pen, periodically. That's my loyal Scalia clerk. Speaking of loyalty to Supreme Court justices, you clerked for Justice Marshall, which just strikes me as this incredible gift. That was at a different time. What was it like? I mean,
It was an incredible gift. I mean, in like every respect. So I clerked for Justice Marshall. He was nearing the end of his career, and maybe he was looking back a little bit. And we were really treated not just to the typical Supreme Court clerkship, which is a great experience, as you and many other people know, but like to a daily history lesson. I mean, he was, in my view, the greatest lawyer of the 20th century. He is an iconic American figure, one of the great people in American history. And we would go into his office every day, and we would do the sort of standard Supreme Court business. We would talk about the cases and about opinions and things like that. But then at some point, that would be done, and he would segue into like storytelling, honestly. And he was the greatest storyteller that I have. It's not only that he had great stories to tell, but he was, in fact, the greatest storyteller I've ever known. He was a sort of raconteur. He was funny. He did impressions of people. He had voices they were very good, and he could. Sometimes he turned it on some of his colleagues. Maybe I won't. But he had facial expressions. He had this marvelously mobile face, and. So it was a little bit like a show, but it was also a history lesson. I mean, there are these people, and we were all in our late 20s or something, and we were being treated to somebody giving us a sort of oral history of some of the most important events of our time. He was, when I say he was like the greatest lawyer of the 20th century, I mean, number one, I would think that he did the most justice, right? And to be in the presence of somebody for a year who had done so much to change the face of America and to make it a more just society was really quite extraordinary in itself. He was also just a fantastic lawyer. He was, and he showed that even as he was a judge. I mean, he was one of the very few Supreme Court justices who really their principal contributions came before they were a justice, right? I mean, he was a very fine justice, but he was a great lawyer in terms of just what he contributed to the country, and also just his skills were very much sort of lawyerly skills. So he was like nobody has a lawyerly career like this, where on the one hand he was a magnificent appellate lawyer. He argued about 25 cases to the Supreme Court and won all but 3 of them. But he was also a fantastic trial lawyer. He roamed around the American South, when it was not easy as a black man to travel around the American South, appearing in these small town courtrooms where, he and his colleagues were the only black faces, and where they were not treated very often with the appropriate respect, and where sometimes they faced real physical dangers, and he had stories about that. But he was a great sort of like little town trial lawyer, as well as sometimes coming up to the podium of the Supreme Court. So he had kind of like all the skills in one, and it was really something to learn from him.
Well, listening to you, when I think of his opinions, they do emphasize the facts. That makes sense,
Yeah,
given his
he
trial lawyer background.
He cared about the facts. He cared about how law worked on the ground. He always thought about how law affected people where they lived. He didn't think of the law as some sort of like abstract. He didn't think about law as sort of a set of abstract ideas. He really thought about law in the way it met everyday lives and affected everyday lives. At the same time, he was like a real rules person. So he was
Rules, not standards, huh?
yeah, he was a rules guy. There was this one case where all the clerks were sort of ganging up on him because like all the clerks were like, well, we have to, fairness suggests we do this, standards, equity. And he was like, no, he was the rules guy. It was a case about whether you could, it was a case about whether you could bring an appeal after 30 days or something. It was a Title VII plaintiff who his lawyer had really messed up, and he hadn't, through no fault of his own, he had filed an appeal on the 32nd day rather than on the 30th day, and.
You didn't make the argument that days don't matter. Did you make that argument?
Well, I mean, we said this is like not a strict jurisdictional rules. It has some kind of equitable exceptions, but he was having none of it. And I remember that he said like all you can expect as a as a person who is maybe not the person that society treats well. Maybe the minority person, the person who is not privileged and who decision makers don't pay much respect to. It's like all you can expect is that they play by the rules. And if they play by the rules, like that's what you're aiming for, to get them to play by the rules.
Right, and he could have thought in Reconstruction, we didn't play by the rules. It really hurt that you could really see that. Well, it's so sad that he couldn't see you become Solicitor General as he was. Obviously,
he was. I had a big picture of him in my office when I was Solicitor General, of him as Solicitor General, and he thought that was the greatest job he ever had. Because I mean, and for him, it was really quite extraordinary to be able to go up to the podium of the Supreme Court, and basically, it's like I'm Thurgood Marshall and I'm representing the United States. I mean, I think for him, it was like how far this country had come.
Well, Brown versus Board of Education would have been pretty nice, but still, I grant there was another bigger docket. So your time as Solicitor General, any favorite arguments? Are there any ways in which that job has affected your approach to your current job?
Yeah, so I was only Solicitor General for a year. And, you know, if you could really do your life, I would have loved to have been Solicitor General for longer. It's a fantastic job. You get to make all the decisions about appeals for the United States. And, you know, so in addition to just the Supreme Court work, you're really in charge of the whole appellate docket for the United States. And then in terms of the Supreme Court, you know, every month you go and if you're SG, you argue the most important case. And, you know, it's really fun arguing before the Supreme Court. It's very hard because there are 9 people and they're all confident and they all have a lot to say and they're all trying to speak to each other at the same time that they're asking you questions, and sometimes you're just getting in the way up there. They're having a very nice conversation, and what are you doing trying to get a word in edgewise? But, you know, super interesting cases, and so you know, you can't say to the president, I'm sorry, could you just hold off and wait a few more years? But I would have loved to have done it for longer. My first case at the court was the re-argument of Citizens United. So Citizens United had been this campaign finance case, which had started off as a pretty small campaign finance case. And it had not gone well for the government. This was in the spring, just as I came onto the court, and one of my associates had done the argument. It had not gone very well, and then on the last day of the year, the court issued a re-argument notice, and it said, in particular, that the court wanted to think about whether to overrule 2 seminal cases about the intersection between campaign finance and the First Amendment. And you could know from the order that basically they were ready to overturn these cases, but they didn't think that it was appropriate to do so without at least hearing argument on the question. So that was my first argument.
Had you had arguments in the lower courts?
Yeah, so, you know, I had arguments in district courts. I had never had an appellate argument, you know, because I had left practice pretty young and then been an academic and then been a government lawyer and a government policymaker. So it was my first appellate argument ever. And, and you know, I was kind of aware that it was a big argument and everybody was going to be watching me, and that was a little bit petrifying. Now, on the other hand, I mean, I can't really tell you that I thought that the fate of campaign finance rested on my shoulders, because it was just so clear what the court was going to do that I felt as though...
Didn't you talk yourself? I always talked myself into thinking I could win.
Yeah, I don't think in this case where they where they issue a you know, you know, you should argue about whether these 2 cases should be overruled after.
This is a motion for reconsideration? I mean,
no, I mean, that's what their order said. You know,
Yeah.
it's like, we're going to hear this case again the next year. And particularly address in your briefing whether these 2 big cases should be overruled. So it was, I think kind of everybody thought that they would just, the answer was going to be yes, they should be overruled. So I thought that the pressure was off a little bit on that, and not to say that it wasn't still a little bit scary, but one of the great things about the SG's office is you work with magnificent people. It's a fantastic collection of lawyers, and you know, so, you know, they taught me a lot about, you know, we did a number of moots, formal and informal. And I get up there, and I remember, you know, I had a few sentences prepared to just say first thing before the question started. I figured people would let me get out a few sentences. I got out one sentence. I think it was like an incredibly anodyne sentence. And Justice Scalia, speaking of Justice Scalia, leaned over the bench in this kind of, you know, way he had and said, "Wait, wait, wait, wait," 4 times. Now, I have to say that when I once told this story, and
in front of him?
I did tell him, but But the way I had remembered it in my head, he said, no, 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 no. And it turned out that I had told it wrong, and somebody corrected me, and it was really wait, 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 wait. But, you know, he had some objection to my first sentence, right? Which was something about the history of campaign finance. But I thought I actually thought he did me a great favor, because he just got me into the argument right away. Then it wasn't like I was making a speech. It wasn't like, okay, what's the next sentence I'm supposed to say, or the next sentence. I was just like having a conversation or having an argument, as the case may be. So, it turned out to be pretty fun.
I found he could be a good foil because you knew where he was coming from. If
Totally.
you could kind of capture the point and say, we understand what you're saying.
Right.
Could be really
And he was
effective.
also good about, and this is, you said, like, does it change the way I'm a judge? And I would say this, he was good this way. Like, he would come at you very hard and tell you exactly what he thought was wrong with your argument. But then he would give you an opportunity to come back, and he would listen to you. And, you know, it's not like you were going to always, or most of the time, or even more than occasionally, convince him of anything. But he would give you an opportunity to say your piece just as he had said his piece. And that's something that I do try to remember when I'm up there. You know, it can, because we all have a lot to say, and I want, you know, sometimes my questions are real questions, but sometimes, I think for most of us, that we're less asking questions than making points that we also want our colleagues to listen to, because it's the first time we ever really talk about a case together, right? And we're going to go into conference in a day or in 2 days or something. And partly the whole way argument is structured is to, you know, have an opportunity to let your colleagues know what you're thinking before you go around the table in conference. But that said, like, I always try to think it's, you know, from a lawyer's point of view, they've prepared so hard for this. And even if they're not going to convince you, you have an obligation, I think, to let them get their points out. So sometimes, you know, I'll say something and ask a question. It won't really be a question. It will be more like a point. And then they'll say something, and I feel as though sometimes I could tell you 6 reasons why you're wrong, but I try to kind of suppress that.
Maybe one.
Yeah, yeah.
Do you ever walk onto the bench and say, you know, this morning I kind of wish I were
There?
the advocate? Yeah.
It's a lot harder than what I do, I think. I think that it's a super hard thing to argue in the Supreme Court. Just, you know, it's 9 people. It's hard to argue in front of 9 people who all have their particular takes on something, and who are all, and at that time, our arguments have kind of expanded in the amount of time that they take.
Yeah, what's going on there?
Yeah, like, we can talk about that. But at that time, the whole argument was compressed into an hour.
So,
So it was
yeah.
usually half an hour, both sides. Sometimes it was 20, 10, 30. So, like, everybody was jumping in all the time. And you could, really, one of the great talents of the people who argued at that time, I think it's less important now, honestly, is being able to make your point in the first sentence or two. You know, that there was, if you were the kind of person who did a bit of throat clearing before you got to the point, well, you weren't going to get to the point. So that was a problem, yeah.
So we talked a little bit about not.
You were in SG.
I was. Thank you for mentioning
Yeah,
that.
so you
no,
were Ohio's SG.
I tell state SGs, I disagree with Justice Marshall. I think the best job is to be a state SG.
Uh-huh.
I do. I mean, it's one state. I mean, the whole 330 million people, you can't make them all happy. I could make the people of Ohio happy. So I,
How long were you?
3.5 years.
And
Plus,
do you ever feel like you want to go over there and get behind the podium?
only if I had 2 weeks ahead of time. But yes, I miss, Justice Ginsburg once said, Jeff, how do you like being a judge? And I said, well, it's a privilege. I really enjoy it, but I do miss being an advocate. And she said, without missing a beat, oh, Jeff, you're still an advocate. I thought, that is not the description of a judge. I mean, I
Yeah,
was
what are you
tempted to
supposed to
say
be
it.
advocating
Well,
for?
it was tempted to say it takes one to know one, but I actually.
Yeah, did she say it as a kind of, like she was making a comment about you? Or was she making a comment about judges in general?
I think she was making a really good point, which I took to be a compliment. And I think the point was, how could you be a judge for a while and not have a perspective?
Yeah.
And of course, that's what she meant. You're advocating that perspective when precedent doesn't control and when there's something gray. And that makes perfect sense to me. You're not going to be a blank slate every case. And so I did not take it as a compliment initially, but I'm so good at rationalizing. I turned it around into thinking, well, wow, how thoughtful. So we talked about Justice Scalia and disagreement and the objective to not take it personally. Hard to do, but it's really good advice. Is there anything else you could recommend to lower court judges? So the other 970 of us out there that we're really focusing on the Court of Appeals judges for now anyway, because we're going to be the ones having the disagreements, right? So we're going to sit in groups of 3. So the 200 of us, we still have disagreements. We still have courts that, when we have in-banks, there seems to be some block voting, and, something about that doesn't seem right.
That never happens at the Supreme Court.
Yeah. Well, anyway, it's a challenging time to be a judge, I would say.
Uh-huh.
And I mean, is there anything you would, someone, I don't know if you have any former clerks. You're so young, it's probably a few years away, but I don't know if you have any former clerks becoming Court of Appeals judges. But what would you say?
I just had my first.
Bingo. What would you say to him or her about how to be yourself? Don't be afraid to advocate for what you think is right, but be a good colleague. Because, I mean, you can't be a one-person show on a 3-person court or a 16-member court. How would you, what would the advice be?
Well, I guess I don't think of them as in tension with each other. That I just think you can be a good and strong judge and also be a good colleague, and that's in fact part of being a good and strong judge.
Mm-hmm.
I don't know, I think people make different decisions and have different perspectives on my court anyway, about how frequently you write separately. I'm a little bit of an institutionalist, so I don't write separately all that often. I mean, I write dissents when I need to write a dissent, and I hope that I write strong and powerful dissents, and that I view that as an important part of what I do. And these days, I view it as a really important part of what I do. But I don't, I try not to be. If you look at how many separate writings they have, usually I'm pretty low down, and because I guess I think that to the extent the court can, the court shouldn't be fractured. I think that really confuses matters for lower courts who are trying to figure out what we're saying to them. I think it's basically not about individual judges. I think it is about the court as a whole and the law. So I try not to be the kind of, I have this to say about this general matter. Now, other people disagree with that. We have a whole very wide spectrum on the court about people who sort of say, I want to express my individual point of view, even when I join a majority opinion or something like that. So there are different ways of being a judge in that sense. I mean, I guess for me, it's important, I think that the court functions best when it's functioning as something of an institution rather than 9 completely separate players.
Well, one thing that's consistent with your being an institutionalist is your view of stare decisis, which you call a doctrine of humility. What did you mean when you said that?
Yeah, I mean, it's only one of the things reasons why we have a stare decisis, why those principles play or should play such an important role in judging. But I guess that particular point is just that. It's that, it's easy to kind of get on the court and think,
what were they thinking?
What were they thinking? And that's just got to be wrong. And my perspective is better. And so I'm going to do things my way. And one of the things that stare decisis does is to tell judges, don't be so fast in saying that there's a kind of wisdom of the ages. And if a lot of different judges have seen something differently, you should, ask yourself and then ask yourself again, are you so sure that you have it right? Maybe all those people who thought something different, maybe they were right, and you should, scrutinize it pretty carefully. Now, that's not to say it's a rigid automatic rule. I mean, there are reasons to overturn precedent. I think most of them have to do with really changed circumstances. Life moves on, our society moves on. Sometimes, it comes to a pass where you've just got to say that a rule has to be changed. But you should approach that with a fair bit of am I sure kind of attitude, and with a sort of sense of humility. I mean, look, stability is also important for the law. People rely on law. There are reasons to keep law as it is, even if it's not perfect or even if it's not right, because you'll be upsetting people's expectations and their reliance interests. So that's another reason why stare decisis is important. Yet another reason is because when the court sort of goes back and forth, depending on individual judges who come on, and then they say, well, they were wrong and we'll do it differently, and then another judge comes along and they say, well, they were wrong and we'll do it differently, and the law flip-flops, and it doesn't really look like law anymore. It kind of looks like a form of politics. And I think that that's especially important for this Supreme Court at this time, that law should not look like a form of politics where just because the composition of the court changes, a whole batch of legal rules change with it. And indeed, our legal, really our legal system changes. And, what was once a right is no longer a right because the court is different. I mean, I think that that's very damaging to the court, very damaging to society. But going back to where we started, it is, a doctrine of humility in the sense of, you put a robe on, it doesn't mean that you're going to make the right decisions. And you should always say to yourself, are there people, if people have seen it differently for a long time, am I so sure I'm right?
Yeah. So you occupy the seat that Justice Brandeis occupied. He's one of my favorite justices, one of the most well-known Supreme Court justices. And, in the early 30s, really before FDR, kind of changes, nationalizes so many things, he has his famous laboratories of experimentation. Brandeis was a progressive. He thought the states had a really significant role to play in dealing with new economic and policy and social challenges, but it is pre-FDR.
Yeah.
And in a way, he's probably responding a little bit to Lochner. Do you think there's still a role for the states to play, or do you think it's just that was then and this is now, and things are really quite a bit different post-FDR?
Well, I feel like I shouldn't be answering that question because you've written whole books about this.
Well, no. So
I want you
I
to
think it
answer
showed
that
remarkable patience from me to take this long into the interview to talk to talk about the one thing I know something about. So no, I'm trying to pin you down.
Yeah,
the states have a role to play, and you're not going.
You go first. The
I-
answer for you is yes.
The answer is yes, and we have just as many tricky problems as the country faced
Yeah.
when Brandeis was around, and it's pretty dangerous to nationalize things too quickly, whether through legislation or court decisions. I think his idea of it is important to point out he was referring to legislatures and not state courts.
Right.
But I would take the view. I mean, I would be curious.
This is, a little bit, we had an argument about this morning.
Yeah, no,
I'm a little bit fearful of going further.
The question presented every turn in American history is what should be national and what should be local.
Yeah.
And that's. But I guess there's an option for localism from time to time.
From time to time. Then
Yeah.
the question is what times?
And how about for progressives? Would you say for progressives?
From time to time. And then the question is what times? It's all a
Yeah,
balance.
you're so evasive. The one thing I was
I'm
most
hearing
excited.
like
The
this,
one thing.
this morning echo in my head.
Oh.
I'm feeling like maybe we should go on to a different question.
Yeah. I hear you. Okay, well then, this is very different. what would you be doing if you had never been a law professor, never a judge, never an advocate? So you got to take your parents' professions off the table.
Uh-huh.
What would you be doing today?
Oh, gosh. I went through a lot of things. In my, there was a moment in time where I thought I was going to be a doctor, but then I just couldn't, stand the idea of taking all those pre-med courses.
Did you take any of them?
Oh, yeah, a little bit. But I don't know, wasn't I, at one point I was going to be the world's greatest tennis player.
Oh, I didn't know that.
Yeah, I didn't, that's because I wasn't, by a long shot. I think when I was in college, I thought pretty seriously of going and getting a PhD and becoming a historian. And then I did my thesis, and I spent a lot of time in an archives and decided, maybe that was a little bit too cloistered for me, and that I wanted something where I would feel a lot of intellectual stimulation, but also feel as though I was part of the world. So it worked out.
I have to say, I can brag, I think I'm the only person in the audience that has read your master's thesis. And it's so good. It's about.
Why did you do that?
It's about the audience knows the MAP exclusionary rule, and what's so fun about the piece, I really admired it because this is pre-law. You hadn't gone to law school
Yeah, I hadn't
yet.
gone to law school.
And I've always suspected you supported the exclusionary rule. Of course, Justice Brandeis hinted at the idea many years before. But the essence of the thesis was to critique the reasoning.
Yeah, that they didn't really
the
ever
reasoning of the court.
find a good reason for it.
Yeah, which is very consistent with the judge you became.
Uh-huh. How was that?
Someone who, it's like Justice Scalia, someone that cares about reasoning.
Yeah.
That it's not enough just to have an outcome you like. And anyway, I think it's terrific. And
What are you, like one in the 3 people in the world who has read that?
We live in a world, first of all, where you can get these
How
things
can you even get
technologically.
it?
You don't have to travel to Britain and get it out, take it out of the library. We have 2 copies. I think a lot of people have read it. I've seen it cited. It is really good. Yeah, well, you have a chance. I don't think you've written about that. I don't think you've written yet about the exclusionary rule.
I have not.
You've got to do that. There's one person
But I
here.
have no idea what I said about it 30 years
Oh,
ago.
you need to go read
Must
it.
be 40 years ago.
Have one of your clerks, they're here. Go look at it. It's really good. Well, so we have, as you know, this is a Supreme Court.
What did you want to do if not be a lawyer?
Oh, I mean, law was 3. I wanted to be, well, first of all, of course, a professional athlete. And look at me, that was school teacher. I did that for a little while. And then I wanted to solve the Middle East crisis. I was born in the Middle East and
Where were you born?
Saudi Arabia.
Oh,
So
gosh.
I always thought I would.
Why were you born in Saudi Arabia?
My father was born in Jerusalem, and we're losing track of the point of this interview. But he was born in Jerusalem to missionary parents, so he grew up in the Middle East as well. So I always thought I would go there and fix the Palestine-Israeli crisis, which it
That
looks
would have
like
been
it'll
harder
be around.
than what you do now.
I know. It's
Yeah.
sadly still there. So we have a bunch of Supreme Court fellows and younger lawyers. And I don't know if this was true for you. I was really paralyzed early on with choices about where to go. And was there any advice about those first couple choices? Because you did private practice a little bit, then you were teaching, obviously after clerking. Any advice to young lawyers about how to think through these next steps?
I think it so depends on individual personalities. I did do a lot of different things. I went after clerking, private practice, into teaching, back into government work. And, for me, that was really important, actually, that I loved that variety, that I loved feeling as though I had done a lot of different things, and that my skill sets were growing, and that every time I felt as though the learning curve had flattened out, there was an opportunity to do something completely new and different, where I could, where the learning curve, shot up again. So for me, that was really important. But you might ask, how does that work in my current job? And it doesn't. So so it's good that I got it's good that I got my current job later on in my life. But other people just find one thing that fills them with a lot of meaning and joy and purpose, and they do that for their entire legal career. So I guess it just sort of depends on who you are. I mean, one of the things that I used to tell students when I was a law dean, I always used to think that law students planned too much. That they would say, well, first I have to do this. I don't really want to do this, but I have to do this because that's the way to get the next thing, which maybe I do want to do, and then and you know, they had their whole lives planned out. And I guess for me, that's not the way life worked. You know, that so much of what I did at any given moment was not because it was on a grand plan, but that, you know, sort of serendipity happened. And all of a sudden I had an opportunity to do something that I hadn't really ever considered. And then I thought, well, that would be fun. I would learn something and I would have a good time doing that. So I always tell people, like, plan a little bit less and keep your eye out more for just unexpected opportunities.
You mentioned the stage when you were both dean of Harvard Law School, teacher at Chicago and Harvard. Did that experience affect your approach to judging at all?
I think the thing that that most affects my judging from being an academic is actually not the academic work I did, but is the teaching. And when I write an opinion, what I think about is how I would teach a class, because I think you're doing much the same thing. You know, you're trying to take these difficult concepts and sometimes, you know, very arcane subject matter. And you asked me before about who my audience is, and I guess my audience is smart people, interested people, but people who don't know a lot about a given area. And that's the way I used to think about law students, you know, smart and interested, but when I walked into a class, they didn't know a lot about it. And so when you thought about teaching, when I did, I thought about, you know, how am I going to explain these complicated concepts in a way that people will get, and also in a way that will stick with people. Like, I think different ways of speaking and writing can be sort of sticky or not. And so that's what I used to think about in teaching, and that's the exact same thing I think about when I sit down to write an opinion. It's like, this is complicated. This is you know, what kind of story am I going to tell? So what kind of story was I going to tell in a classroom? And what kind of story am I going to tell on the page to make people understand what the problem is and what we're doing?
Yeah, I had no experience teaching law before being a judge, but I will say teaching law after being a judge, if I think of the areas where I'm not inclined towards stare decisis, or I'm in, you know, obviously as a lower court judge, we would follow it, but I would be quite liberated about critiquing a doctrine. It would be having taught the doctrine and having seen students try to figure
Struggle with it.
Right.
Yeah.
Or seeing lower court judges struggle with it. I mean, that's probably the one area where I'd like to think I'm always trying to be humble, but boy, if you see something that no one else can figure out, I do feel like that's a good time for us to at least identify it. And so I think teaching can be super helpful there. How about, so I think you're close to your 14th year. This is hard to believe.
I think this is my 14th year,
I mean,
isn't
close
it?
to the end of the
Yeah,
14th
yeah,
year
uh-huh.
as a justice. Is there a way in which there's been live and learn changes? I mean, if you were comparing those first couple of years of how you worked with your clerks, how you interacted with others, when you wrote separately to today.
You know, it's funny. I mean, I guess some things have gotten easier just because they do get easier. Things that took a long time my first year don't take so long now. But I actually think that I'm pretty much the same person doing the same job. The court has changed, of course, and my role in it has changed some. But in terms of like the way I think about judging and the way I do judging on a day-to-day basis, I think I'm more stable than not.
And writing's the same, even the writing separately point. You were saying that you started as an institutionalist? That's impressive.
Yeah, I think I did.
Didn't Justice Stevens talk to you? I mean, Justice Stevens was one of the people who wrote separately the most. You took his chambers, weren't there, like, write whenever you can, all over the... And that didn't affect you?
I guess I don't feel that need to, like, I have a thought here, so I just want to tell the world about it, you know? I mean, I tell the world about my thoughts when I have a job to do, which is like I have a majority to write because somebody has assigned a majority to me, or when I have a dissent to write because I think the majority has gone very wrong. I think that there are a lot of times when I'll read somebody else's majority opinion and say, you know, I would have done something a little bit differently. I would have stressed this rather than that. You know, there's an additional point that I would have put in. I guess I try not to do that. I think, you know, yeah, I don't know. It's not about me.
That's always a good thing.
Yeah, it sounds a little bit like I'm patting myself on the back, but you know, I'm part of like a group project, and the project works best when we act as an institution, which, you know, sometimes we're incapable of doing. But, you know, it's good
Because
when
it's
we
hard.
do.
It's difficult. You guys get asked to do a lot. Anything you would recommend to lower court judges about things we could do a little better than we're currently doing?
I feel like you should tell us stuff, and here's the reason, and I don't say this to flatter anybody, but I think that you guys have much harder jobs than we do. I mean, I think we, number one, have incredible lawyers at the Supreme Court bar. I mean, almost all the lawyers who come up to us are, you know, just fantastic.
Doesn't that make it harder? I sometimes see
No, I
these
think
cases that look
it's
so
like they
easy,
give
and then you get
these,
7
these
smart
great
people.
briefs and these great arguments, and you have all the raw materials. And the other thing that we have that you guys don't have, like all we have to decide is basically a single question. You know, by the time the case
Well,
comes up to us,
I had to clarify, you don't have to do anything because you get to decide what you decide.
that's true. That's true too. So
That is
that's
not
right.
lost on
So
us.
We'll put that on the list too. And then when we do, we've sort of distilled a case to a legal question. Whereas you guys, you get these cases and they're messy and there are all kinds of questions and they're colliding with each other and different people want you to answer different things. And you have to kind of make sense of messy stuff in a way that I think we much less frequently do.
Yeah. Well,
And then we write these fractured opinions, and we don't even tell you how to, you know. So that's why I'm against fracture.
You have everybody on that. I mean, maybe there should be a 9. This goes back, maybe, you know, not that we want 8 justices, God forbid, but I did notice a court that did have a lot more unanimity when you had only 8 justices. I don't know if you remember. This is post-Justice Scalia's death.
Yeah,
Right?
I mean, it was a very interesting time for the court, and I've talked about this before. I thought that there's actually something to be said about a court with an even number of justices rather than an odd number of justices, because it forces compromise where you don't think compromise is possible. And sometimes it led to a little bit of, you know, silly decision making. It's like, oh my gosh, well, we have to do something. So we would find some way to agree on something that was like what nobody cared about, and nobody was, you know, that was not the question, the real question, and it was not an important question. So there were times when it felt a little bit silly, but there were more times, I thought, many more times, when it actually felt as though it forced us to have a conversation that was useful and valuable and that did produce greater consensus. And what it usually meant was that, you know, even when people disagree profoundly on big stuff, they can usually find smaller stuff. So if you sort of ratchet down the importance of a case and of a question, you can usually find something to agree about. And there's real value in that, you know, just making things a little bit smaller so that you can agree on more and actually send a signal about the possibility of agreement in law. So,
well, it's really not a Supreme Court if it's 4-4, right? It means the lower courts affirm, so they're not the Superior
right, so
Court.
we tried hard.
You have to.
I mean, we tried hard not to do 4-4, affirmed by an equally divided court.
Yeah.
And as I say, I actually thought it led to some really great conversations among the justices. You know, because when you go around the table and you come out 5-4, I mean, all the incentives are that people stop talking at that point, right? They've reached a decision, and you know, what's the use of banging it around more? But when you come out 4-4, well, then there is a benefit to, you know, keeping on talking. And when you kept on talking, it wasn't just that one vote would change. You would just often find a way to reformulate the question and to, or just, even if not that, just a way to think about something from a different angle so that many more people could agree.
Yeah. So we just lost Justice O'Connor, and I'm trying to think. Did you know her? Had you gotten a chance?
I didn't know her very well. I mean, she was off the court by the time I became Solicitor General. I knew her a little bit when I was a law school dean. She came to Harvard a few times then. She gave me some nice advice when I became Solicitor General and when I became a justice. But I didn't know her very well, but I had enormous amount of respect for her and what she did as a justice.
Are there any legacies at the current court that are Justice O'Connor legacies?
Yeah, well, it's hard because I think some of Justice O'Connor's great moments have been abandoned by this court, and it's a little bit maybe the fate of a swing justice who was extremely important in her own time because she was basically making the calls on some incredibly important subject matter areas, and then the court's composition changes, and turns out.
So fewer case decisions. How about culture?
But I think, notwithstanding, I guess the reason I have such enormous respect for Justice O'Connor is, so she was in this sort of unique situation where she was making the calls on pretty much every important decision that came to the court. And in our country, most of the important decisions in the country come to the court in some way. And if you said that to somebody, like all the important decisions are going to come to this one court, and then there's going to be this one person who just so happens to kind of be in the middle of the court who is going to decide it. I mean, somebody would say, well, that's the craziest constitutional system ever. Like, why would you have a system like that? And the thing about Justice O'Connor, I feel, is that she made it work. Like, she made it work because she had an incredibly good understanding of the American people, and she had an incredibly good understanding of the nation and what the American experiment meant. And she was probably not the justice who had the most sophisticated set of ideas about judicial methodology or anything like that, but she was a person who really got what the court could do and what it shouldn't do, and who really who was able to sort of chart a path where people thought, those outcomes, they're probably the right outcomes. And I think she left the country much better off than she found it. She left the court much stronger than she found it. And what more can you ask of a justice than that?
Yeah, no, I worked, in addition to Justice Scalia, I worked with Justice Powell, and he was very similar to Justice O'Connor. And one of the things that, I'm not really asking you to comment on this, but it does seem to me a sad reality. There's no world in which a person like that gets on the court today. That world doesn't exist, where someone either doesn't have opinions about law. Justice Powell, he was just a lawyer, hadn't thought about any of this stuff. And Justice O'Connor had been a judge, but she hadn't charted out where she was on those things. And it does seem like a loss not to have people like that on the collegial court. Happily, we do have them on the courts of appeals for what it's worth. So, there are plenty of them out there, but the selection process has gotten so intense. You have to. So, but none of your answer about Justice O'Connor has to do with her being first. And I guess you would say is that because that's now irrelevant? We don't need to talk about that anymore?
I think it's sort of extraordinary. I mean, she gets on the court, and she is the first. And she hadn't had the background that some of her colleagues had had, and I'm sure that there was a lot of skepticism. And then it turned out, she could do the job better than, so she showed them.
Well, she was a great questioner. She never hid the ball. She usually
started things off.
Started things off, so you knew where to look as an advocate, and it was always straightforward. The visual cues were usually quite clear whether she liked the answer or not. And
what did she do?
She was not afraid to frown. I mean, I'm not saying it was a mean frown, but it wasn't a smile. But it was good. I mean, you said with Justice Scalia, the downside is he didn't let you do more than one sentence. The upside is you knew where he was coming from, and then he listened when you gave your answer, and she was clearly, and of course everyone was listening to her question. So then you'd have a lot of reverberation from that question. Well, Justice Kagan, the country is so lucky to have you as a justice. And you know, the fact that you chose on the day of one of the biggest cases of
Well, I didn't
term,
really choose it.
No. Everything's a choice. You easily could have said no, and I arrived. Even up to 3:15, I wondered how this was going to go, and you put a smile on your face and came over here, and I just have
Judge
to.
Sutton, the country is lucky to have you as a judge. Judge Sutton is an
no.
esteemed Court of Appeals judge and a great chief judge now.
Well.
And so thank you for being the person who sits in the other chair.
Well, thank you so much for doing this, and thank you for your leadership on the court.
Thank you.
Thank you. That was great.
Thank you very much.